So if everyone is ready, we will start the second and the last session of the conference. But first, I would like to once again welcome our guests, most notably Cesare and Victor, and of course everyone else. Today we'll have a chance to listen to two speakers with different topics, and yet as almost everything in law, it's quite related, and of course their approaches are quite different. The first one is more sociological and institution based, the other one is, let's call it, purely philosophical, and it will be quite interesting to hear these two authors. First one with chance to speak will be Cesare, and I should say it's somewhat different because he will speak about the concept of the statute from the standpoint of one of the 20th century French philosophers, whose name I'm not sure I can pronounce correctly. Maurice Thoreau. Okay. Who was a legal theorist with a background in sociology of law and legal history, and who later then used that knowledge to develop a distinctive understanding of the concept of the statute. But I'll stop there and leave it to Cesare to give you more details.
Okay, so exactly, I would like to present you some ideas of this French scholar.
You can use this to change it.
How does it work? Okay. Yes, exactly, I would like to present some of the ideas of this French scholar, which maybe has been a little bit forgotten for the past century, but remains really important in France and maybe can be useful for us in this international discussion about constitutional law. And thanks for the invitation, but I would like to start my presentation so that you will have some of these ideas. The common definition of the statute understands it as an enactment of legislative authority establishing rules that have general and abstract character. Therefore, it is conceived as a set of prescriptions that are to be applicable for all the situations or the cases that will occur in the future. Such concepts presumes an absolute and reasonable character of legislature. This idea constitutes the very theoretical base of the continental law systems, whose core principles are strongly influenced by normativist thesis in legal science. In these systems, the role of judiciary is then strongly limited to the strict application of the statutory rules. In this regard, they are opposed to the common law systems, defined on the contrary in terms of judge-made law. However, some of those fundamental presuppositions of normativist thesis cannot be sustained given many contemporary observations about the complexity of legal decision-making processes. So, in short, many of them have been proven to be fictive and oversimplifying the general concept of legal work in a manner that is not corresponding to the reality. The normative theories of law and legal positivism tool, fostering the above-mentioned concept of law, were strongly criticized from the very beginning in the first half, particularly in the first half of the 20th century. It is during that period that work Maurice Oriot, who is a famous French professor and theoretician of public law, who was a great opponent of normativism. He established his own called institutional theory of law, taking into consideration, as other social legal studies, the historical and actual social context behind legal processes. He was an academic of public and constitutional law at University of Toulouse. The beginning of his career were marked by the interest in the history of law and sociology. Even if the Oriot's works have been a little forgotten, they are really important because he was an inspiration for such thinkers as Santi Romano, McCormick, Weinberger, Deleuze, or Carl Schmitt. And the most important idea of Orius theory is his theory of the institution, and I think it is crucial to present it briefly to make legible the ongoing comments and the ideas that I will present. According to the last version of his definition of the institution from 1925, the institution, and I don't think I will read that, but maybe you can see that on the screen. The institution is an idea of a work or an enterprise which is realized and continues to be realized in the social environment. For the purpose of this idea, a certain authority is organized which provides its organs. On the other hand, among the following members of the social group interested in the realization of this idea, the manifestations of the community are held, led by the authorities and regulated by means of procedure. Then the law, we can say, is perceived through the prism of social bodies, acting as a part of some more general social order. These bodies, the institutions, are supposed to shape what we finally call the law, defined, in fact, as secondary to the institutions themselves that constitute its origin. So, inspired by social sciences, Oriu claimed that the study of law should be based on concrete facts, events, and phenomena, avoiding any kind of abstract notions and abstract thinking. In the result, Oriu put forward the idea of thinking about the law as an effect of a very concrete, material process of auto-constitution of the society. The principle is that the law is shaped by a sum of individual acts concerning some social relations, which define through their content the social order, the general social order, and those individual acts are directed by some cultural common ideas of, for example, justice or equity. But it should be stressed that none of those acts can be considered as an absolute source of law, detached from the particular context in which it is produced. So I will pass to Oriu's concept of the statutory law, which was obviously strongly critical towards normativism. As for the role of the judiciary, I think it's that. Oriu argued that the absolutizing the statutory law as a set of general and abstract rules oriented towards the future is one of the dangerous concepts inherited from the French Revolution ideology, based on the idea of the absolute and general will of the nation expressed by the legislative. In fact, as believed Oriu, the statutory law should not be considered as something more than a work of codifying customs, accepted solutions to the cases encountered in the past. The legislative is then, as any other human being and human institution, limited in its capacity of predicting future and all possible particular solutions to future situations, impaired in its heuristic horizon mostly to what has been already a subject of law or legal decision-making process. In the above-mentioned work, he described written law in the following way. I think you should have it. Sorry, but I will read it. It must therefore be admitted that written laws and organic laws regulate only in a present-day manner certain elements of the state, certain elements and certain procedures, but that the institution of the state, considered in its profound realities and its fundamental balances, continues to be legally sanctioned by a customary consent in which constitutions and organic laws are embedded. So the real nature of the statutory law is then constituted by the customary consent that is at the source of the validity and normative force of law. For, as argues Oriu, the statutes would be nothing but some paper sheets without the social recognition of their content and values that they express. It is, by the way, important to mention that Oriu's model of power inverts the traditional scheme of the governed individuals, transferring their power to the governing minority, the government. He proposes his own schema based on the idea of social recognition and acceptance of particular social groups and organizations pretending to have power over society. They have to be constantly assured if they have enough of customary consent backing their enactments. Oriu articulates the idea very distinctly. As he says, the common law, it is essentially custom and not the written law. The idea of the statute law as an ideal form of lawmaking process is, in his eyes, a fruit and a sin of the revolution that aimed at banishing the old legal system to dispersed, heterogenic and complex, trying to replace it by the new unified legal order composed of statutes. Nevertheless, Oriu doesn't condemn the idea of the statute itself completely. He underlines the importance of the statutory law regarding the principle of equality, but is very critical towards any attempt of absolutization of the statutory law technique, as he says. He argued that the strict normativism can be dangerous and create some sort of abstract man, whereas the idea of justice requires from time to time some differentiation. In order to proceed, in order to proceed prudently with the statutory law, or being cautious with the statutory law, both in lawmaking and legal decision-making processes, Oriu considers statutes in the first place as a work of codification of customs, and then as an attempt to present them in the form of general and abstract rules. So, in fact, the statutory law is destined to simplify the legal order and not to change its very nature, balancing between the general and the particular. Nevertheless, Oriu says that the statutory law incorporates also a second component, that is the social will of change. The stake of the modern law, according to his theory of institution, is to assure balance between stability and the revolutionary forces that are both present in society. With this perspective, he distinguished two aspects of statutory law. As he said, the law is a historical combination of regulation and custom. Then, a junction of regulation as expression of the governing power will, individual will, and the custom that is based in the society practice. It is important, however, to stress that Oriu defined the statutory law, first and foremost, as a lawmaking technique. Oriu's vision of statutory law is based on a strict materialistic analysis of this process. As he said, a law, and it's visible on the screen, a law is manufactured as an industrial product through various devices and following a wire rope. In his theory, he stresses the fact that the positive law can only constitute some sort of approximation of the ideal law, but will never become ideal itself. The statutory law is therefore no longer the expression of the abstract reason, but an effect of a complex process of its elaboration. To demonstrate the concept of the statutory law present in Oriu's works, it is convenient to analyze how he argued in favor of the permanence of validity of Declaration of the Human Rights and of the Citizen from 1789, which at the time of the Third Republic, when Oriu worked, was no longer formally a part of the French legal order. So he was trying to argue that the declaration is still binding because there was no formal constitution assuring some fundamental rights or liberties. In order to prove that the declaration remained in force, he argued that it is not the text itself that was formally still binding, but the fact that the French society has profoundly adhered to it and internalized its principles. As he said, there are many fundamental principles that can form constitutional legitimacy situated above the written constitution. Apart from the republican form of government, there are many other principles for which there is no need of text because it is proper for principles to exist and to be enforced without a text. In this vision, the text itself is only a material tool of law, just as it was before the French Revolution. we are able to identify that it is precisely the modern concept of legislation that he fought against, and that is work of French Enlightenment philosophers. As defined by Denis Baranger, this concept, as I said, inherited from the French Enlightenment, not only French, also English or American, is linked in its essence to the constituent feature of ourselves, our historical and social feature or identity. That is to say, our natural way of political existence, and that consists in that we aspire to give ourselves our own laws. So make political community in autonomous manner. And that was the idea of enlightenment, which was fully convinced about the man rational nature, capable of analyzing the world and extracting the general and universal laws of nature. As he argues then, this modern vision of human nature got realized really as a practical or even technical cognitive enterprise of legislation, which was oriented towards social change. The statutory law, as a practice known already before, gained then a new meaning and the key role in the modern law-making practice. And this modern concept of statutory law was obviously far from homogenic. It is possible to observe two tendencies in philosophy. The first, conceiving the legislation as an act of cognition, and the second as an act of will. In the works, for example, of Jean-Jacques Rousseau or Montesquieu, the lawmaking is described in categories of an art of discovering universal, and I would like to underline the word discovering, universal truth that governs social life. And the second way, more present in the philosophies of more utilitarian philosophers such as Jeremy Bentham or Cesare Beccaria, they admitted that law is an act of will of the person who governs, but his decision-making process can be considered as rational work of projecting some social change in purpose of assuring better life conditions of people. Nevertheless, in the course of the 19th and particularly 20th century, this concept of law turned out to be largely or even excessively idealistic. The law has strongly devaluated. It is not consistent. It is not even rational. It has become some sort of political illusion. And the law seems to have lost the efficiency and even its legitimacy. So the history of the modern idea of the concept of statutory law, of written law, appears then as a story of some, we would say, rise and fall of a grand narrative, a great concept. So it's the critic of postmodernity. Postmodern critic, the great concept of the statutory law as the supreme source of general and abstract rules, having reached its top in the doctrine of normativism, had to submit itself to changes provoked by urgent needs of legal practice. In order to maintain justice, also nowadays, the role of the statutory law is to be interpreted with many restrictions, which is observable in the judiciary dimensions of law, which we are speaking today about, in particular within constitutional and international courts, where the relation between politics and strict law are the strongest. The interpretation of the statutory law as written custom presented by Oriol could then be applied in the analysis of the contemporary jurisprudence and theory of law. In his works, the statutory law has been described, taken into consideration all the heuristic limits of the figure of legislator and the strict materialistic and discursive nature of legal practices. Considering the statutory law as written custom, meaning the nature of law as something turned to the future but anchored in the experience of the past, can help us understand why it is sometimes, and more often necessary, to let the judiciary step into the shoes of legislator by distinguishing in order to maintain justice. Thank you.
Now I give the floor to Vasily, who will provide some comments.
Yeah. Good afternoon, everyone. First of all, I would like to congratulate to the organization for hosting the student conference for the sixth consecutive year. And this is my second time at the student conference in theory, philosophy, and sociology of law. In 2018, I was a participant as well as our colleague from Poland, and this time I have a role as a commentary. I think, first of all, that this type of communication is very important for every single student, because in that way we can develop our critical judgments, which will be quite important in our future in order to perform well in court, whether we're going to be lawyers or judges or something else. We will have to know to listen, to speak, and to polemicize. And I also think that it is important to do so in the early stages of our careers. Second of all, I would like to thank to all of the participants, especially the foreign students, for deciding to come to Belgrade, and I'm very glad that this conference gained international character. So thank you all for contributing to the reputation of our faculty here in Belgrade. So my colleague has picked an interesting but a complex topic, and I admire your courage for doing that. And considering that the subject is distinguishing in statutory law, and the fact that it is mainly, if not 100%, based on Maurice Oriou's works, I'd like to praise the fact that you have used original works of Professor Oriou, which as well mean that you speak French very well. The significance of the author using original works and not the works of other writers is quite big, because when writing the text about someone's theory, using the original work, you're not paraphrasing the paraphrased. And it is the best way to give your own opinion on some of his or her work in this moment, and yes, of course, I would like to add that I'm not saying that you should avoid text of other authors, but as you didn't, of course, I'm just saying that that is the best way to explain it. In the beginning of your paper, it is written that the statutory law is a set of prescriptions that are to be applicable and applied in all cases that will occur in the future. And I think that the word all is quite necessary in this sentence, because the legislator always counts on legal gaps, or in Latin, lacuna juris. The legislator can never anticipate every single case that will happen in the future, and in that manner he is leaving space for the judicial interpretation. Instead, it might be better to say that the legislator has an intention to predict as much as possible future cases, but never all of them. And I agree with you that the enactment of legislative body should be harmonized with reality. That is very important in order to society proper function. In the next segment, I think it's good that you connected Oriou's institutional theory and lawmaking process. That way it is easier to understand his theoretical position. I read another article about Oriou's work that's called La théorie de l'institution et de la fondation. You used it as well. And Oriou thinks that the basic function of an institution is contained in securing social stability and order. And the institution does that by, as you said, shaping something that we finally call the law. So he asserts the relevance of institution in his theory. On the second page, you didn't mention it right now. I mean, I assume because of the lack of the time, but you said that Oriou inspired many theoreticians such as Santi Romano, Otto Weinberger, Carl Schmitt, and you could add also Arnold Gellen in his theory of institution, which is obviously closely related to Oriu's institutional theory. In the second part of your paper, where you're explaining Oriu's concept of statutory law, as you said, it is believed by Oriu that the statutory law should not be considered as something more than a work of codifying customs, as accepted solutions to the cases encountered in the past. With this viewpoint, I think that Oriu wanted to emphasize the importance of legitimacy of legal norms in statutory law, even though he was the opponent of normativism. Because without legitimacy, statutes would just be a dead letter with which no one would be taking them as binding. Later on, Oriu says that the statutes can overgeneralize the reality. And I would say that sometimes to generalize is the point of statutory law. But of course, generalizing can sometimes become over-generalizing, but I think that is a sacrifice that the continental law countries are willing to take and are ready to take because, I quote you, statutory law is destined to simplify the legal order. And I don't see that as a bad thing, as Oriu does. I actually think that it is the key to solving many different cases, of course. And not only because of that, it is also the sacrifice that they are ready to take because, as you said on the last pages of your work, that the statute became the most important tool when opposing tyranny. Oriu distinguished, as you said, two aspects of statutory law. I'm not going to repeat what you said. I just want to say that I found the most interesting that Oriu, when arguing in permanence of the Declaration of the Rights of Man and of the Citizen from 1789, he was trying to prove that the Declaration still remains in force, even though it was no longer formally a part of the French legal order, legal normative order, of course. And he was saying that it is not the text that is formally binding, but the fact that the French society has profoundly adhered to it and internalized its principles made it still valid for the legal discourse. I appreciate you mentioning this part of his comprehension of statutory law, because from it we can see how strong he thinks and how strong customs are. However, one should be very cautious when saying that customs are sometimes stronger than enactments of a legislative body, because in modern times it could be extremely dangerous to put legitimacy over legality. But that rule should not be unconditionally respected. If we go to the other extreme, and if someone is blindly obeying to the principle of legality, that would not be good as well, because as the ancient Romans spoke thousands of years ago, lex injusta non lex est. My opinion is that distinguishing in continental law could sometimes harm legal security, or in other words, cause legal insecurity. And I think that there has to be a difference between distinguishing and judicial interpretation. Because continental law system is already functional for a long period of time, and although it might not always be possible to predict the future cases, I think the amendments to the law are sometimes something that we are destined to live with in this system. However, some legal practice shows that distinguishing is possible in contact with continental law. As an example, I would take the International Criminal Court, which combines the institutes from common law and continental law systems. And I'd like to conclude. My final opinion is that this is a very interesting text, and laconic, if I may say so. And I want to thank you again for coming and being a part of the conference, and I hope we'll see you again next year.
And I will write some more. Complete.
I'm glad to hear it.
Okay.
Thank you, Vasily. Cesar, you now have the chance to answer to the comments made by Vasily.
Okay. Or the
Or we
question.
can collect all the
I can
answers.
no. I can answer those questions. Okay, I made that point, so I don't know. Okay, so maybe from the last. When I use the term of distinguishing here, it's because he doesn't mention even once distinguishing in his text. That is my conclusion. And the term of distinguishing, I would like it to be interpreted in the most large sense it can have. Because I think that he believed that many of legal practices that we have, such as legal reasoning, trying to reason in a consistent and coherent manners, is in fact distinguishing without naming it so. Like judiciary feeling that we should make an exception to the general and abstract rule, but is making really some like I don't know, like an extremely gymnastics to say that it is not distinguishing but the process of interpretation of the norms. The next, when you said about lex injusta, so the problem of justice or equity, I didn't say that, and after my presentation, you can have the impression that he was really critical and based in social sciences. But he, even when you see the article on him on Wikipedia, you will see that he is qualified as a member of the School of Natural Law because he believed that the justice and equity is the sense of the law, is the essence of the law. But it was just in the, I would say, in the prescriptive sphere of his theory, and in the empirical methods that he proposed, he was strictly, like in social sciences, limited in our I don't know, possibilities to seize the concepts of justice. So yeah, but he was the member of the natural school, so he was always, it was really important for him for the justice to be realized in the legal process. That is why he criticized normativism as something that rejects the concept of justice, replacing it by the rule, by the natural rule of general and abstract thinking. For the simplifying, as I said, and you mentioned it, he said that the modern concept of statutory law was conceived in purpose to simplify legal order, and he was not criticizing the simplifying itself, but he said that oversimplifying can be dangerous.
Yeah.
So when we make general and abstract rules that don't take into considerations that there are some people, like minorities, that we really have to, in order to maintain justice, make exceptions, make less general rules, less abstract rules. And just to, I think, just to end my response to your commentary, I even wanted to mention it in my presentation and in my text, but I didn't make it because I didn't find it very simple. I didn't find the reference to some bibliographical reference, but I wanted to illustrate the concept of for you by the way that in ancient Greece, the ancient Greeks represented the time. So in ancient Greece, people had a vision of time as a man who is going towards the future, but has its back turned towards the future and is looking into the past. So he can predict future, but only looking into what has already happened. Is never capable of seeing what will happen in the future. So, as he was saying, the work of codification, the work of legislation, is always a work based on our experiences of the past. So we can make general and abstract rules, but they are always a work of really a materialistic, real process of considering the cases that we have already encountered in the past, the questions of justice that we wanted to resolve. And the last I wanted to add, as you mentioned, legitimacy over legality, just a short remark. He never conceived, for example, legislative bodies like parliament as the institution that can be absolutized, that can be considered as the source of this general will, because it's not the representation of the nation. It's always a distinct body from the society, and it is in a secondary manner accepted by the society, but it is always a body that is distinct from the society and is expressing its own will. It's a constituted body that is expressing its own will, and maybe in the process of maybe in the future, this will be accepted, and that is mostly the case in democracies. Maybe it will be accepted, but it's not the fact that someone said something, like even if it was parliament, that it makes law. It's not the source of law itself. It's secondary. Okay, thank you.
All right. I'll now open the floor to the general discussion. I believe that Mayor has prepared some very good questions. So
I don't know about that. Thank you both for the comments in the very interesting discussion. So my question is always concerning what many 20th century legal scholars are kind of grappled with, and that is the authority. And my question to you is that, so if I understood correctly, and I obviously did not agree with it, but from the ensuing discussion, the laws that it seems that Oreo does take law to be a source of authority. And it gives reasons to people to act, and so on. And is also cognitively and phenomenologically moves people.
Yeah.
So my question is, if we think about H.L.A. Collins, for instance, and his theory of reduction, right? You get authority because people accept and so on and so forth. That has, I wonder what you think about the criticisms against this kind of materialist reductionist movement, specifically what happens today in the context of multicultural societies, where you have oftentimes at least a considerable portion of society not actually accepting law, yet nonetheless normatively moved by it. So,
I think I will answer this question with mentioning Carl Schmitt, because Oreo was the inspiration for him, even if it was a misinterpretation of Oreo that inspired Carl Schmitt. But it is true, and it's a response to your concern about our modern heterogenic multicultural societies, because he said that the very I don't know how to say that, it can function, the system of law function the best in the communities that are the most homogeneous possible. Because if we have diversity, we have the problem of authority. That is, it's not so sure that a multicultural society will, in general, have the same values. So they will not support the same authorities. That's why in many countries we have many authorities, in fact, that produce normative systems beside the law. And yeah, it is true that he said that in his works. That inspired Carl Schmitt to make his concept of concrete legal order that is really based, that is destined for a community that is really homogeneous. That is the concept that was used by the Nazi. So that's it. He was conscious that the diversity is a problem for the power, for authority, for law, in consequence.
Thank you very much for the presentation. It was my first approach to this author, so maybe I hope not so many questions. First of all, the institutional theory of law is descriptive or prescriptive approximation of the law?
That's my question. That's marvelous question.
Because if it's a descriptive approach, it will have some serious problem. First of all, it wouldn't difference that the legislator create text, not meanings. Meanings are attributed by the judiciary, and they can choose between enormous amount of legal techniques to attribute meaning. So if it's a descriptive theory, I think it's a problem, and if it's a prescriptive theory, why should we consider it for our purposes? The second point is you said that we should take in consideration balancing between the general and the particular. But I think this is a problematic distinction because a particular thing, object, fact, whatever, is an exemplification of a type, of a general category. So and it can be, it can have two aspects. It could be relevant for normative purposes or irrelevant. But what gives normative relevance to a certain simplification of a type is that it's contained, I think, in a norm. So you will have in all this explanation one or two things, or a conflict between norms that exist or a reinterpretation of the legal text. And finally, you have the point in the bottom is that all of this is written custom, recognized. How do you recognize customs? And how do you differentiate relevant customs from irrelevant customs? Thank you very much.
Yeah, very good questions. The first descriptive character of the theory, I would sum up his theory as a descriptive theory with some prescriptive aspects. So it was a theory that was to describe how the law is made and applied. But the prescriptive part of his theory was if we consider the law, the legal order as an order that is constructed by the institutions that say what is law, that elaborate the law, then and that is the prescriptive part of his theory, then we should make all those institutions cooperate in the best way. I mean, he said that it is only possible to be functioning well if the institutions cooperate with themselves. Even if sometimes one institution must resign from its opinions or statements about the law. So, for example, he said that not only the judges must be conscious about the limits of the legislator, but also the legislative bodies must be conscious that they have to take into consideration what has been revealed after, for example, promulgation of a law. So as he believed, there are no laws, written laws, that are to be eternal, and they should be reformed with cooperation with the judiciary. And there was even a mechanism in the First French Republic that was criticized by Oriol, but there was a mechanism that when a judge was not sure about the constitutionality of one text, he was supposed to make his statement and then send this statement to the parliament, and it would be discussed then. This mechanism never entered in force, but there was such a proposition, and that is, I think, also that is one of the propositions that would be this part of prescriptive aspect of his theory. So the cooperation of the institutions that are, and I think it's really actual. I mean, now when we have this tendency in philosophy, in social philosophy, of the reflexive philosophy, I think it's the concept that all the institutions must be conscious of their limits, and that is the reflexive part of his theory. The next, I will respond very shortly. He rejected the concept of a norm as the fundamental concept of law. He said it explicitly: the law is the legal order. The norms are just the products, the elements of procedures of this cooperation between institutions. And for the written custom, that is a genius question. I think he didn't answer that, and I won't be doing it in his place, because he just said that it is for the judges to choose what customs are binding.
Okay, can you just,
Yeah, go ahead.
is there another question? No? Nobody?
Yeah, I have.
Okay, then.
So, like, my question is very simple. Like, do you call an unqualified law or uncodified custom a law? Like, a custom can be a law, and if it is not a law, then can it be challenged for example, like it's violative of anything that is written in the constitution? Because in a political, there would be a group that will recognize certain unwritten texts which have the force, like you quoted that text which says something which are not in the constitution, but they have a force which must be obeyed to. So my question is that if a custom is not a law, then can a custom be challenged to say that it is violative of the something which is recognized in the constitution as against something which does not exist in the constitution? And if it can be, then should the judges do it if the political recognizes that there is a set of group who believe in certain customs, and for their existence they should not be touched, because like you have like in Latin American countries or in Asian countries where there were indigenous group of people who draw their legality and their existence from a certain set of defined rules which are emphasized by a group. So is it a question that judiciary should deal with, or the judiciary should approach it with a judicial take off position? So
Yes, it's also problematic in his theory, but maybe it can be explained. I mean, he wanted the concept of the general will of the nation to be replaced by the concept which is now well known and even challenged now, the concept of public opinion. So he thought that judges, and for example, I don't know how it functions in other countries, but for example, in Poland, in the constitutional court, the judges make very often reference to empirical studies about society, and I think he believed that it is a task for the judges to be some kind of scientifics, I would say even. So a judge, when he makes a legal decision, has to base it on some research on the society, so that he knows what customs or values or principles are socially really recognized. And then even in the sociology, not even in the social sciences concerning law, there are some concepts of normativity that are based, that can be, the normativity can be gradual. So we can say, for example, that the principle of equality is normative in 19% because 19% of the population thinks that it is recognizes it, has it internalized. But it's really difficult. His theory is really difficult to be applied because I would say of those 200 years of the experience with normativist approach to law, he made something really different from the normativist approaches, and I think that is why his theory is only some kind of a short proposition, not a theory that is, or that could be a theory with a T major.
Well, actually, now I really thought about. First, I thought that there is a problem, even if the theory is descriptive, even if it's prescriptive. I have the reasons, but now that you said this, I think that there is this mechanism that maybe is based not on his theory, but at least to me, it resembles. So, for example, you know how the European Court of Human Rights, when deciding the cases, they have to. They have to take into consideration the practices and customs of each member state to define the margin of appreciation. And so basically what they do is they go back to customs, and usually the customs are for them as margin of appreciation. That's like their easy way out, not to go very far away. But I actually think they use that method so basically their adjudication never goes beyond the customs of European member states. So in that sense, there is, I think, the empirical evidence of this method applied. But on the other sense, I think that I looked at it, when I heard you, I looked at his theory in that specific historical framework, because later, I don't know, for example, how legal transplants would fit into this, because, for example, there are like post-colonial countries who completely adopted legal systems which are not reflected in their own society and their own values at all. So how does that function in a descriptive, if you take the descriptive account? So I don't think that would fit. But now that I remember the European Court, I think that that's a kind of example of this material.
I would just add, and maybe you can answer together. When you were talking, I thought about conscientious objection. So this is probably a recognized way of in law of having exceptions for specific groups which may have additional reasons not to comply with the law. So first you mentioned that a declaration was understood by him to be still valid because people adhere to it, but what about what happens with the norm when the exceptions to it becomes so fragmented and expands because of these different ways of having reasons to have exceptions as conscientious of objection. So does the norm die out because there's no norm anymore?
Yeah, it's a challenge. I would say he was very Aristotelic in his theory. So he said we should have a balance of general and particular. So we should have norms, but on the other hand, we should have power to make exceptions, but not exceptions that make the norm invalid unless it's really devaluated.
Anyone else? All right. Well, thank you, Cesare, and thank you, Vasily, and I will now call.